Welcome to Trust the Leaders podcast, a podcast of Smith, Gambrell & Russell, a full-service corporate law firm with 7 domestic offices and 3 international offices. Today, we are here with John Spillman, a partner in corporate in our Atlanta office, and Marc Latman, a partner in our corporate practice in the New York office. Both are members of the task force of our COVID-19 team. Our subject today is part of SGR's CARES Act series, Paycheck Protection Program. We are revisiting a webinar that we did in April and talking about the changes and things that many of our clients and our contacts, referrals need to know. So Marc, tell me a little bit about why we are revisiting this topic.
Sure. Thank you very much, Lee. The big reason is the issue of the Paycheck Protection Program. Also, you'll hear me refer to it as P3 sometimes, just out of ease. A lot of others refer to it PPP. I think we'll all know what we're talking about in this instance. But it's been ever changing since it came out, and understandably so. It's a humongous lending program, probably the biggest lending program as far as the number of people it's going to have as borrowers. So it's the biggest program that's ever been developed, and developed extremely quickly, obviously in response to the economic shutdown of the United States. So there are changes on nearly a daily basis. There are changes to even what the previous guidance has been. So we want to make sure that we're trying to get out to our audience the most up-to-date information and correct any prior information that may have been given. Another reason for touching on this now is the program was so popular that within 2 weeks it had run out of its appropriated monies, and I think it was just the beginning of this week. I think this Monday it was reappropriated with money. So again, a good time to revisit it, because people who were not able to borrow under it the first time are probably looking at it this time, although the money's probably going just as fast. And then there has been, over the course of the last 2 weeks, there's been a lot of political discussion going on about the program, and sort of believed misuse of the program, and certain large companies having access to monies. So our elected officials, Secretary Mnuchin, have come out fairly strongly that people who borrowed money on this program need to be real careful and need to be sure that they meet the criteria of the program. And there is a May 7th deadline, sort of a safe harbor deadline coming up. So we thought that we wanted to get this out to the audience to make sure we're giving them the information about it.
Yeah, definitely. And I know that since our webinar, there has been clear guidance on headcounts for both qualifying for the loan, the famous 500, and for forgiveness, correct?
That's right. I think that there's so much overlap between what's referred to as qualifying for the loan. Do I have 500 people or meet whatever exceptions there are to that 500 number? But then again, there's a second part to this loan, which is the forgiveness piece, and your head count is measured again, and they're two totally different measurements. That first 500 is determined whether you're eligible for the loan, at all, and it takes into account full-time, part-time, everybody, affiliated companies, unless there are exceptions, for it. So that number you can probably arrive at, or hit that number, pretty quickly based on the structure of the ownership structure of your organization. Forgiveness, though, is quite different, and where it's based on what they refer to as a full-time employee equivalency. So and that we believe that it's actually the full time we believe is measured off of a 30-hour work week as compared to a 40-hour work week. But more importantly, just to make clear that the forgiveness piece, it's not the measure of 500 anymore, but it's the measure of how many employees were employed before, full-time equivalent employees were existed before, and how many are existing at the end of the measurement period, which is June 30th of this year.
Okay, so is there any mention of affiliates with this? So again, I think as you start to move into the forgiveness piece, you can see where people start questioning. Well, when I'm measured against what the FTE was, or what am I paying the employees the same that I was paying them, before the pandemic occurred, what am I measuring against? Because again, going in, I had to aggregate amongst all the affiliates. We have the view that we're taking is it's a measurement of the borrower. So you're looking at the FTE head count of the borrower. You're looking at the salaries of the borrower's employees, and you're not taking into account any of the entities and their employees through the affiliates. Right. So speaking of affiliations, is there a limit, and you may have mentioned this, is there a limit on the number of affiliates that can borrow, or an aggregate amount that the affiliates can borrow collectively? And John, feel free to jump in whenever you would like to contribute and comment on any of the questions.
Well, okay, Lee, thanks. On the question of whether there's a limit on affiliates that can borrow, and there were a lot of vagaries on these issues. The guidance came out recently, and it made it clear, or at least it made it clear by implication, that there is no limit on the number of affiliates who can apply for and get a PPP loan, assuming they are otherwise eligible to borrow after applying all of the affiliation rules in terms of the size eligibility criteria. So if there is a corporate group, for example, with 10 subsidiaries, and after applying all of the affiliate rules, all of those subsidiaries are eligible for loans, that is, that the entire group is under the size test established, each subsidiary can apply and obtain a loan under the regular criteria. But yesterday, or in the last couple of days, the SBA has clarified that in addition to the $10 million limit per loan per applicant that was in the statute, a loan within a corporate group, there is an additional limit of $20 million. So if, for example, if you had 5 subsidiaries in a corporate group that were eligible to borrow, they could still borrow and get individually PPP loans subject to eligibility, but those loans could not add up to more than 20 million total, or 10 million as to any individual loan.
And John, just you mentioned that corporate group, the corporate group, and we have affiliates, and there's a distinction between the two, isn't there?
Yes, and that's a good question, Mark. The affiliate group is used on the front end to determine eligibility of any PPP borrower. That's an existing SBA concept that's been around for a while, that's been imported into the PPP program. And using those affiliation rules, the borrower is required to go up to its ownership and find any other businesses that are controlled or under common control or controlled by that borrower. And that looks up multiple layers and you add all of the employees in that group together, or all of the revenues in that group together, in order to see whether the borrower satisfies the size limitations, which are there are various size limitations we talked about in the last webinar, mostly 500 employees, but some others. And that is the only that is the only context in the PPP loans where the affiliate concept comes into play. Once you've received the loan, once the applicant is eligible, applies for the loan and receives the loan, the various employee counts and payroll and other tests on forgiveness and use of proceeds are only involving that particular applicant, and not the affiliate group. The corporate group, which is used to determine that $20 million limit, is a narrower concept, and that means an actual group control, a corporation and its subsidiaries, which is a narrower concept than the broader affiliation rule.
Thanks. I think it's probably also worth noting, as you said before, this is a change. I think as early as yesterday, which April 30th or April 29th or so, talking about the constant change that's going on, and this is a big change in that it limits the amount that a group can obtain, even if they met the other sort of the other aspects of the rules. And I think this is a change from what was originally planned and expected by the program itself, not just people trying to access the program. And I think it's important to note that it seems like the government thought that there was this was a hole for some sort of abuse, because I noticed that they were also making it the responsibility of the borrower to return the funds if they're in violation of this, or if their loan hasn't been funded yet, to sort of repeal the application. This only goes to people who the money hasn't been fully funded, I think by April 30th. So I mean, people who last week had applied and received money, it's not necessarily applicable to them, but people who are going through the process now, if their applications, again, the rules have changed on them, they need to be aware of this, because there's an obligation on them not to take the monies, because there's a certification that gets made in the application that you haven't received funds through any other, you haven't received P3 funds in any other manner, and it seems like they're considering this, that you would have received your fill of P3 funds.
I think that's exactly right, Mark, and I think this is in large part a reaction to headlines and publicity that several large companies in the hotel and restaurant industry, which were given special eligibility beyond the 500 employee count from the affiliate rules, use that exemption and got loans among many subsidiaries, adding up to many tens of millions of dollars, which resulted in some bad headlines that implied that big companies were abusing the program at the expense of the smaller companies that it was intended to help.
Right.
So, and I'm sorry, Mark, did you have something else to add to that?
No, go ahead. Go ahead.
So just in determining compensation for the $100,000 employee, what constitutes compensation? And then when is that determination relevant?
Right. I think this is quite similar to the headcount issue that we opened up with. There are multiple times when you're going to be concerned about or measuring the particular salary or compensation of employees. The the first part is when you're determining the amount of the loan. So sort of the application process, you're not allowed to include compensation given to employees to the extent it is over the $100,000 mark. And there were questions about, well, what constitutes that that portion of the compensation. And I think there was a lot of confusion over it, and I think there's been a bit of clarity on it, saying the cash compensation portion of salary is what goes towards determining whether someone has $100,000 in salary. You can then ask, what is cash compensation? Because to me, it can mean different things, but certainly any sort of stipend that an employee would be receiving above their salary, for housing, food stipends, cars, and anything like that is considered cash compensation. What seems to not be considered cash compensation are payments or contributions that are made on behalf of an employee through the pension programs, the healthcare contributions, and then the employee portion of state and local payroll taxes. So that is not counted as part of the $100,000 amount. And that again goes into the sort of the application size when you're determining how much money you can request to borrow. And then when you're determining forgiveness and your use of the proceeds, did you properly use the proceeds? Are you allowed to pay someone over that $100,000 equivalent using the P3 funds? The answer is no. And it's also a measure. It's also used. I like to refer to these. If there are any employment law lawyers out there listening, maybe hold your ears as I use the words exempt employees. I consider these $100,000 employees to be sort of exempt employees for purposes of these P3 loans, because there are requirements that you cannot lower salaries during the February to June 30th time period. That there is an exception to that, and with respect to these $100,000 employees, if you ended up lowering their salaries, that's not counted against your forgiveness piece of your loan. So those are sort of the application phase, and then sort of the spending / forgiveness phase to make sure you've used the money in the right way.
So what happens if a company cannot use all of the funds within that 8-week allotted time period?
So, we've had a number of clients come to us, and say, we're actually receiving more money than we think we could spend in accordance with the rules. And just to refresh people's recollections, there are really two pieces that go to or maybe three that go to the spending of the money. The first is from the day that you receive money under the program, you have 8 weeks from that date to spend that money. It needs to be applied. You can't hold on to the money. We've had lots of people ask us, is there a way to delay sort of the start of that 8 week, that 8 weeks? We had laid off employees. We're going to hire them back, but they're not back yet. What do we do? And the answer is no. You need to spend that money during that 8 weeks. You need to spend. And let me restate that. I say these things that you need to spend that money, and that is for what I'll call the forgiveness piece of the loan. You need to spend this money in that 8 weeks to have a chance at 100% forgiveness. Similar to that, you have 75% of where the money is spent in order to receive 100% forgiveness is towards payroll. So 25% of those of the funds received can go towards other permitted expenses. Those things include, again, payroll, the costs related to group health insurance, and now some of these are what I'd call employer expenses in in running the company and having employees. Payments on interest of a mortgage obligation, rent, such as on the lease of office space or a factory, utilities, and then interest on any other debt obligations that were incurred before the covered period. I think that last part's important. You can't go out now and sign up a lease, take a mortgage, incur other debt, and expect those to be eligible expenses under this program. It's all things that were existing expenses of the company, so you're able to use these funds to pay off those things that you entered into before this pandemic happened. So even if you have borrowed more money than you think you would pay out on payroll, there are other expenses that can be paid for, and that it's important that they be eligible expenses. Once you get outside of those eligible expenses, you're gonna lose the forgiveness aspect of the loan. Actually, I shouldn't say that. Once you get outside of the eligible expenses, you actually start to be in violation of the program, and the government could come after you for improper use of the funds. As long as you are using them, for the permitted purposes, even though you couldn't spend it all in the 8-week period, it seems to me that you would have a 1% loan for the 2-year period. So as long as you continue to spend that money on those types of expenses, you have that ability to convert this, rather than at 6 months having all of it forgiven, the portions that isn't spent on or isn't forgiven would turn into that 2-year loan. The other thing that you can always do is return the unused portion, or the portion during that that you're not able to spend during that 8 weeks. You can return it during that period of time as well, and certainly lessen your obligations with respect to those monies.
Okay. So now there was a time when banks considered funding through multiple drawdowns, whether to spread out their payment obligations to be able to accommodate more loan requests, or as a safety if it turned out that the borrower was not actually qualified for the money. So can you touch on what banks are now required to do, single drawdown loans? Can you elaborate on that?
Sure, John. Maybe we turn this one over to you, but I think this is just another example of things that have changed since the beginning. And I think if people were relying on the FAQ guidance that the SBA and the Treasury have put out, and if you read down them, I think you would probably see points in time where multiple drawdowns were permitted. But I think there's been a change in tune on that, John.
Yeah, the SBA has made it clear that the loans will be dispersed in single draws. That either that was just for efficiency and because the mechanics otherwise would make it too hard, or because people were trying to use the timing of the drawdown to game the 8 weeks. But it's been clear in the FAQ that the 8 weeks starts from the first disbursement of the loan proceeds. There are a bunch of issues that are still interesting and not fully clear, just dealing with the mechanics of the banks processing and disbursing the loans. One that came up yesterday that I've not seen any real clarity on is that the Act itself makes it very clear that the PPP loans are not secured and do not require guarantees. But most borrowers, or many borrowers, are borrowing from the banks where they already have their primary indebted, their primary lines of credit and term loans. And under those existing loan documents with that bank, there's typically a clause that says that all future advances from the bank in any manner would be secured by the the pledge of collateral for the original loan, and the new PPP documentation doesn't carve that out, and it's very unclear how those two concepts interact with one another. But there are quite a few issues like that in terms of the mechanics of the loans from the banks and how they interact with existing debt.
Right. So there have been questions about professional employer organization, PEOs, and private equity portfolio companies, and whether they are eligible for P3 loans. In the first instance, are they the employer? And in the second instance, are the portfolio companies all affiliates of one another and might then exceed the headcount threshold for eligibility? Can you, both of you, explain the PEOs, what PEOs are, and then advise if there's clarity on whether they can qualify?
A PEO is, it used to be called employer leasing. Those are organizations that handle all of the payroll and HR aspect of an employee on a kind of a turnkey basis, and the employee expenses are passed through the PEO. And I believe the PEO is a statutory co-employer in some states, and there's a lot of IRS and state employment law rules that go along with that really do not have anything to do with PPP. But that caused confusion initially because it was not clear who the employer was for purposes of a PPP loan when it came to businesses that use PEOs to handle their employees. And there's some related relationships as with managers and other things. And the FAQ from the SBA came out and did clarify that the underlying employer was the employer, and that the payroll documentation from the PEO could be used to establish all of the records that need to be verified on that. It also made clear that that you can't double dip. The PEO or the manager can't apply itself, and we've had situations where that was not clear, particularly in management situations, hotels and assisted living and other businesses, where it's a little bit less of a clear pass through than a PEO. And in some cases the manager applied, and in some cases the owner applied. And both of those might work, but it's important to make sure that there's no double dipping, and before applying, the applicant needs to be sure that the other side of that relationship is not also applying, so you don't have two loans using the same employees as the basis for those loans.
And I think the private equity issue is probably a little different. I think there are probably two pieces to it. And I know John has looked at these in particular. I think early on there were questions, whether private equity firms, hedge funds, were eligible for loans themselves. I think there's been guidance put out again. I think it's it's either through the FAQs or the interim final rules that make it clear that those hedge funds and those private equity funds, they themselves are not eligible. And I think that's historic through the SBA program. And they use language about they're in the business of speculation, and that is not what SBA loans are meant to be used for. But probably a little bit more importantly, where people are asking the question is if they're a portfolio company of a private equity firm, and whether they themselves could qualify. And I think the guidance there is you have to do the same analysis that you would for any other company and go through that affiliation analysis. And if you would fit under that affiliation analysis, just because private equity firms and hedge funds are excluded, that doesn't mean that the portfolio companies are excluded because the parent, so to speak, isn't eligible. But you do that head count and to determine whether that portfolio company would be eligible. Because again, for hedge funds, private equity funds are going to own large numbers of portfolio companies, and the head count certainly might exceed that 500 number pretty quickly. But otherwise, if you can fit within the guidelines, I don't think there's anything that excludes them. Do you, John?
No, I think it's a practical matter because of the structure of most venture capital private equity funds. The affiliation rules, if they have been if they've been investing for a while, they typically have enough companies in their portfolios that the affiliation rule analysis would effectively keep them out of the PPP program because of the cross ownership and control. There was a lot of optimism and lobbying early on that the affiliation rules, which again predated the PPP program, that those would be loosened to permit private equity portfolio companies that otherwise met the size criteria to participate, and we had mentioned that in our webinar, but that did not happen, and the guidance has made it pretty clear since then that that's probably not going to happen, and that the existing affiliation rules would be applied strictly, and the practical result is that most PE portfolio companies and VC portfolio companies would be ineligible. There is one big exception to that that has been particularly helpful for lower middle market private equity portfolio companies, which is a broad blanket exemption from the affiliation rules for companies that have any SBIC financing, and that's a small business investment company. It's a form of private equity or private lending that is already registered with the SBIC, and many private equity, lower mid-market private equity portfolio companies in particular have mezzanine and other and sometimes some equity financing from those SBICs, and even a relatively small amount of SBIC financing will make the company eligible, even if the affiliation rules otherwise would have knocked it out.
Right.
Lee, I know we're coming up against our allotted time, and I know there was one topic that we wanted to make sure that we got to. So should we go ahead and jump to that one?
Definitely, that P3.
Okay. So this is this is the issue that I alluded to, is one of the reasons why we're doing this webinar now, coming up against this May 7th date, where there's been a lot of political and even public backlash about some people that have borrowed or are trying to borrow under the program, feeling that the program was never intended for them. I think some of the problem behind that has been that people that or organizations that probably do qualify or were intended to be recipients of this are now questioning whether they should be recipients of it or not, and asking the question as to whether they should return the funds or not, what they should do. Should I even apply for the loan if I haven't yet? I'm afraid of making this certification that I need the money because of the uncertainty of the economic times right now. John, anything you want to say about that? I mean, I know both you and I have counseled some folks already on this point, but any particular pointers that you want to give?
Well, the one clear takeaway from the guidance is that they wanted to discourage public companies that are that have ready access to capital markets from participating in the program, even if they qualify under the size criteria. And a lot of the headlines that were embarrassing to the program came from those public companies. They are also clearly trying to make all borrowers who may not be desperate for the money think about whether they really want the money, without giving many specific criteria for what they ought to be thinking about. They have reiterated in the guidance that the certification about necessity of the loan, whether it's necessary or not is obviously a vague term. And what they've said in the guidance is borrowers must make this certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. If you add all that up, it really doesn't.
Crystal clear, right? Clear, right?
I would say that the only thing that makes clear is that if you know your business is in great shape, you're sitting on a lot of cash that'll take you through whatever period of uncertainty you can foresee, and you just want the free money, then you should think twice about it. It doesn't give a lot of guidance to the broad, normal swath of smaller mid-market or under 500 businesses that may be doing okay, but that realize things could deteriorate and whose other sources of liquidity would be much less advantageous than this. And
almost everybody's has to be 1% unsecured up to 2 years, right? Almost everybody's has to be. But I don't think that's going to be. I'm agreeing with you, of course. But they seem to be getting at, if you could borrow money at 3%, 4%, 5%, you should be borrowing money at 3%, 4%, 5%, which is funny, right? Because usually, they made a big deal, and I think even in the same statement where they were talking about this, how usually the SBA program, loans, you have to make a certification of, I wasn't able to get money elsewhere. There wasn't an economically viable, alternative path for me to take. And then and only then can I come use your money, SBA. And they specifically waive that here. And yet they go, reading what you just said again, they're now, the guidance that has come out is, take into account the current business activity and your ability to access other sources of liquidity. It seems like exactly what but go ahead.
Mark, I would put a lot of stock into the last part of that. I would emphasize other sources of liquidity sufficient to support their ongoing operations in a manner not significantly detrimental to the business. A non-forgivable loan that adds to your debt load that is at a higher interest rate that may take you some time to obtain and qualify and apply for, and that would tie up collateral, all of that, even if arguably available, could be significantly detrimental to your business. So again, in my opinion, unless the borrower is really in a rosy situation, I don't think this guidance should give them a lot to worry about. But it is something to reflect on, and I think that it would be more likely to affect a forgiveness review on a larger loan than it would be to send somebody to jail in a gray area case.
Right. I think that's right. And when we talk about larger loan, I think we're talking about $2 million and above, because again, the Secretary Mnuchin came out, and then the FAQs indicated that every loan for $2 million or more is going to automatically go through a review during the forgiveness phase in respect of whether that certification was given properly. And that brings you to that May 7th date, and that you can return the money, sort of no questions asked. You'll have been deemed to have, when you made the borrowing, you'll be deemed to have met the requirements of that certification, so the government couldn't come after you for it. So I think that's what people are going to be weighing over the course of this upcoming week when that deadline looms. But again, I agree with you, John. It's the perspective. It's a matter of if you're sitting there, I'll use the phrase fat, dumb, and happy. That's probably the people they're looking at.
Yeah. Well, we are coming close to the end of our time. This has been a really great conversation. We have so much more guidance for P3 available on our website. We do have an SGR COVID-19 resources page. If any of our listeners would like to visit our website at sgrlaw.com, and you will see the resources page from our homepage. Thank you again, both Marc and John, for this really enlightening and informative conversation. How can they reach you if they have more questions?
Well, they can come visit me at home while while we're all locked away. Let me go ahead and give you the personal address. You can drive by. I'm sitting here pretty bored most of the day. In any event, you can certainly for me, you can reach me through the office phones or ring through to the cell phone 212-907-9787 or mlatman@sgrlaw.com. Maybe easier just to go on the website and find me that way.
Okay.
And yeah, the website is probably the best way to get my contact information to reach me for questions.
All right.
You don't want visits at home?
All right. Thank you so much. And again, please follow us on Twitter, LinkedIn,